Hello, this is Matt on the Moon Lambeau channel. The SEC is kind of playing dumb right here, and frankly, I don't think they need to play dumb, but here we are. They're in part pretending like they're doing what they were ordered by the court to do, delivering documents. And it seems like a fine little song and dance, but in the end, you'll see that this is really just yet more evidence that the SEC, at least those employees of the SEC participating here, are a bunch of punk-ass bitches. That's what Mike Tyson would say, and I can guarantee that. So I'm going to run through the specifics here because there's a new filing every day, right? At least one per day, if not 55, right? It's hard to keep up with, to be honest with you. But I'm going to share with you comments from 3 attorneys within the XRP community on this exact topic, because the SEC has been court-ordered to produce documents having to do with Bitcoin, Ethereum, and XRP, and a couple months have passed, and they haven't done it. It's been over 2 months, and they absolutely have not done it. And they're just, it seems like a delay tactic, right? Which is harmful to Ripple's business. And then in the meantime, I'll talk about this more in a separate video. I mean, I touched on it a little bit in the past, but they're seeking an extension, right? They're seeking, I believe it's a 60-day extension. And part of the reason that, if they're backlog, part of the reason probably is because they've had a bunch of documents created and engaged in motions and all sorts of irrelevant nonsense discussions that were of your own creation, SEC. And so, if you've not had the time to do what you were supposed to do, maybe if you weren't being a bunch of asshats, we wouldn't have this problem. I do want to be clear, though, I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who makes YouTube videos as a fun hobby about Ripple and XRP and crypto and asshats. But that's all that's going on here, guys. Nothing else to see. And if you don't like it, you can get out. All right, so I'm going to have to touch on this document that was sent in by Ripple's legal team. This is from June 4th, 2021. I made a thorough video on this, so I'm not going to rehash all of it. But I do need to make sure we have the table properly set here, or you're not going to understand what I'm talking about. And even for those of you that did see the video that I'm referencing here, I think we could all use a refresher. And so this is a Ripple writing to the court saying, hey, SEC not handing over what they're supposed to hand over about Bitcoin, Ethereum, and XRP, which is completely relevant and important to Ripple's fair notice defense. And so they wrote as follows. Dear Judge Knepper, we write on behalf of defendant Ripple Labs, Bradley Garlinghouse, and Christian Larson, the defendants, to request a local rule conference. Although Ripple and the SEC have resolved several discovery disputes, there are 2 sets of SEC documents as to which the parties are at an impasse, and we ask for an order compelling their production. Additionally, we ask the court to set a date certain by which the SEC must produce the Office of Investor Education and Advocacy correspondence and the internal SEC documents that Your Honor ordered be produced back on April 6th, 2021, and reaffirmed on May 6th of 2021. And so that office, so they, just to be clear, documents need to be pulled from a number of different parts from the SEC. That's what I've gathered here. And so this is the Office of Investor Education and Advocacy, which is OIEA for short. And then this continues. The SEC did not appeal either of those discovery orders, yet, in the 2 months since the initial order, the SEC has yet to produce to defendants a single OIEA response or a single internal document. And please remember that part right there, because this is relevant, as you'll see as we go on here. SEC has yet to produce to defendants a single OIEA response or a single internal document. The SEC has repeatedly delayed its production while telling Judge Torres that the ordered discovery was, quote, irrelevant and needless, end quote, and asking the court to extend the discovery deadlines based, inter alia, on the fact that defendants, quote, have raised a number of concerns regarding the SEC's review and production of internal documents and communications responsive to Judge Netburn's April 6th order, end quote. And this is where it gets kind of funny to me. This is what Ripple's lawyers wrote. In other words, the SEC cites its own delay as a reason for extending the schedule. There you go. Yeah, look, we haven't been able to get around to it. I know we're ordered to do this. We haven't been able to yet, though. So we just have a 60-day extension, right? It's of your own creation, SEC. And so they then write, this is Ripple's attorneys, the only way to solve this problem is with strict deadlines. And so then we get to this. XRP community member James Filan, who is an attorney, shared this most recent document and wrote the following. This is the SEC's response. The SEC has filed its response to Ripple's motion to compel the SEC to turn over the internal Bitcoin, Ethereum, and XRP documents Judge Netburn has already twice told them to turn over. And just wait, because as I run through this, you're going to see, I mean, the way that they word this stuff, it's very clear to me that they don't want to do. It's like they've sent indications that they've started working on it. It's like, hey, we're doing it. And you'll see as I go through this what I'm talking about. But then just 2 months has passed and then there's nothing. So check this out. I highlighted, actually printed this up. I killed some more trees here for you guys. And then I highlighted it. Highlighted. Probably highlighted. And what the most tasty morsels of all of this here that I want to cover with you. This thing's long enough that I wouldn't want to go through the whole. I mean, it's 4 pages, so I mean, like, yes, there have been longer documents, but I don't want to read the whole thing. I just I got some parts that I think you're going to find rather interesting here. Let's start here at the top. Defendant's request, and so again, this is the SEC, writing to the court, bitching about Ripple. This is why we can't have nice things, folks. Defendants request that the court order the SEC to produce by June 18th, 2021, and then there are actually 4 things. Number 1, email inquiries sent to the SEC, and then they cite an email address sent to that mailbox, and related responses to that. And then number 2, responses to email inquiries sent to the SEC's Office of Investor Education and Advocacy, that's the OIEA again for short. 3, intra-agency memoranda or formal position papers, including all privilege logs. And number 4, and this is my favorite part, can't wait to talk about this. Number 4, internal SEC policies applicable to its employees' trading of digital assets. The first 3 demands are largely moot. Defendants filed the motion without completing the meet and confer process of those demands. Had they instead concluded that process in good faith, they would have learned that the SEC was largely willing to agree to their requests. So let me pause right there. But you weren't communicating that to them. They've been contacting you, and you've had communication for 2 months. And you know that after 2 months, of course, Ripple is not going to be thrilled about the fact that you've not presented what the court has ordered you to present. And now that they finally took the next step, it's like, okay, we're at our wit's end. It's not happening here. Now you say, oh, but if you just talked to us a little bit longer, you would have found that we were okay with some of this. Okay, SEC. Now that's disingenuous, but this is what we've come to expect from these team of asshat lawyers, right? And then they write, a defendant's 4th demand has no relevance to this case and should be denied. Oh, what? Again, that's number 4. That's the one I'm most excited to talk about. Number 4, again, internal SEC policies applicable to its employees' trading of digital assets. Ripple wants information on that. They want to know what the SEC employees have been investing in, because might there be a conflict of interest in the way that they behave, in the way that they view XRP. Maybe they don't own any XRP. Maybe they don't like XRP because they don't own any XRP. Maybe they want the other digital assets they own to do really well. And the SEC says effectively here, and these are Moon Lambo words here, but the message they're communicating is that it does not matter what interest the SEC has in any cryptocurrency assets, because their position here effectively is, oh, no, it's not going to change any of our behavior. Do you buy that, folks? Do you buy that? They're saying that whatever any of their employees are doing in terms of investing in cryptocurrencies doesn't matter. They're the SEC. Of course that matters. Have you heard of the term conflict of interest? And so, not that you'd necessarily need to know what every single employee at the SEC is doing, but doesn't it matter what those with those employees involved in this case, the SEC versus Ripple case? Doesn't it matter what they're doing? Perhaps wouldn't it be worth knowing if there's a conflict of interest? I don't know. It's just the SEC pretending like there's no relevance there whatsoever doesn't ring true to me. Now, I don't know if that's something that the court's going to go. I don't know what side the court's going to fall, because I don't have a legal background. I don't know what's likely. I'm just saying from a logical perspective, of course that's relevant. And then they wrote the following. Oh, this is super duper fun too. Since the court's April 6, 2021 order requiring the SEC to search the emails of 19 custodians identified by defendants for certain communications with third parties relating to Bitcoin, Ethereum, and XRP, the SEC has reviewed tens of thousands of external documents and produced approximately 25,000 documents to defendants starting just days after the April 6th order. Right. And so, to me, it's like sleight of hand. But look, we did this thing which is not addressing all of the concerns that Ripple brought up. Do they... Yeah, they might. I hope not. Do they think the judge is that stupid? Because I don't. I sure as hell don't. A sleight of... But here's something that we did, but ignore this other list from Ripple about all the stuff we haven't yet done. All the stuff that's quartered, no. But look, there's 25,000 documents, and look, I don't know what's in those documents. I'm not sure, but Ripple has stated, and that's what I opened the video with. As soon as I got to the meat of the content here, that document from June 4th that I just ran through, that intro part right there. Ripple made their case. They're like, we don't have this, we don't have this, we don't have this. And now they're saying, okay, but we sent these 25,000 documents. Now, again, I'm not privy. I don't know what those are, but it's not what the court has ordered to be sent in. Thank you, SEC, for nothing. This is why we can't have nice things. Just saying. Really grinds my gears, folks. And then let's just go here. Check this out. If we get back to point number 4, because on the 4th page, actually, they talk about point 4. And the SEC attorneys wrote the following. The SEC's internal trading policies have no bearing on the Howey analysis in this Section 5 case. The Howey analysis is just as objective as Ripple's fair notice defense, and it turns on, quote, the knowledge and the objective intentions and expectations of the parties, end quote, to the transaction. A non-public SEC internal document governing the conduct of SEC employees who were not parties to the transaction at issue has nothing to do with the treatment under Howey of digital assets and can have no relevance to the objective Howey test. Okay. I haven't seen Ripple make the claim specifically that it has something to do with the Howey test. If they have, fine. It looks to me like they're saying Ripple didn't. It's like a straw man argument. That's what it appears to me as. A straw man argument. Oh, that's not like the Howey test. But then they state here again, a non-public SEC internal document governing the conduct of SEC employees who were not parties to the transactions at issue has nothing to do with the treatment under the Howey of digital assets. Okay, but what about the employees that are involved in the SEC versus Ripple case? Because you're making it out as though it has to be literally the conduct of every single employee. That's not what Ripple's legal team asked for. I just read to you at the beginning part of this video verbatim what they asked for. That is not what they didn't say. Literally every single employee. It just seems like a straw man argument to me. So why this is relevant? Conflict of interest is a real thing, and then you start talking about the Howey test. Where the hell did that come from? It's just the arguments with the SEC. They're so weak that they're just going in all sorts of different directions. It's what I keep saying when I make videos talking about the progression of this lawsuit, or in this case, regression. I guess so. It's just all these illogical arguments. and they bring up stuff that isn't relating to the actual complaints that are being made, and they're just behaving completely unethically. I don't believe that they believe the arguments that they're making. I simply don't. But it's so flimsy what they're arguing. They just got to argue anything that they can, and they just see what sticks. It's disgusting and awful. And so attorney Jeremy Hogan, he retweeted that tweet from attorney James Filan, and he wrote the following, and this is kind of funny. I believe that the SEC has indeed been expeditiously reviewing and producing documents as it argues in its response to Ripple's motion to compel. In fact, I've obtained a behind-the-scenes picture of the SEC's litigation staff working hard to comply. And what is the picture? If you care to look at your screen right now, you can see it. It's a bunch of elderly women playing bingo. There you go. That sounds about right. I think they probably are working for the SEC right there in that picture. I'm willing to bet that is indeed the case. Then here's a tweet from XRP community member John Deaton, who is an attorney. He's an important attorney because he is the attorney that is seeking to intervene in the SEC versus Ripple case, and we shall see how that goes. But he wrote the following on this topic because he retweeted James K. Filan's tweet also, and he wrote, in short, Ripple has asked for the SEC to produce its non-public internal policies governing SEC employees' purchases or sales of digital assets. The SEC claims that these documents are irrelevant. Because our motion is pending, I won't comment, but you sure can. And I did. I absolutely did, yeah. I think this is relevant, but now it's time for you to comment. I would love to hear from you in the comment section below. What do you think about, especially, you can comment on anything in the video here, but or just what you had for breakfast. Somebody's going to be like, I had a banana. But as far as specifically that point number 4, that's the one I personally am most interested in. This idea that the behaviors of the SEC, what they're investing in, this or that, like, is conflict of interest matter, ultimately? I say yes, and I have a feeling that John Deaton would say something more or less in line with what I've conveyed. But once things have progressed further, maybe we'll get to hear from him, because I don't know for sure, but that's just a suspicion I have. But I'll go ahead and wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Nambo. Banana.